Hello and welcome to the Rogers Brief for April 14th, 2023. I'm Adam Rogers. Thank you for watching and thank you for listening. I'll be covering, as I do here in these videos, the stories of the week that have either a legal angle as their primary focus or as perhaps an underappreciated side of a legal story. And this week I'm going to start off with just a very brief commentary about the Mass Casualty Commission update. There was a final update that they issued this week, and I'll talk about that for a minute. The session of the Nova Scotia Legislature, the spring session, has just ended. 14 days, so a short sitting where they passed the budget and some other legislation. I'll talk about that for a moment. And an update on the school stabbing knife incident at CP Allen High School in Bedford. There's been a further court appearance there with some an interesting new development. And then I'll leave Nova Scotia and look at a couple of Supreme Court of Canada cases that came down this week. One is on impaired driving, and another is on the abilities of a province to bring in restrictions on the possession of cannabis plants. And finally, two more things. One, this issue in the Prairie Provinces versus the Federal Justice Minister. That's been in the news quite a bit nationally. I'll talk about that some. And then finally, there's an interesting case. It's a bit of an older case, and it's out of Australia, but it caught my attention, and I thought just bring something kind of interesting on a self-represented case in a foreclosure case out of Australia. So we'll talk about that a little bit at the very end. All right, so first, the Mass Casualty Commission issued an update on April 13th, and wasn't much, just sort of a final update to say, all right, we're not going to be monitoring social media channels anymore, the Twitter and Facebook accounts, emails for the Mass Casualty Commission. Their work is done. They urge everybody to commit to change, and even in what they call in the face of interconnected and complex challenges. So they are urging people to read the report and act on it and get to work on change. They do also note that they have a timeline, sort of not an interactive, but a moving timeline feature on their website for the what happened portion. I've used that timeline. It's other than the fact that there may be some mistakes in their conclusions about what happened, the actual timeline and being able to break it down sort of minute by minute, and you can just sort of push a bar across the screen, and then on the side, then things will pop up. All right, this is what happened at that time. So it's a handy thing. It's linked onto their Mass Casualty Commission website, easy to find there. So something people may want to check out. May also want to check out this Sunday night. I'm going to be back on the Nighttime podcast with Jordan Bonaparte and Paul Palango, talking about more about the Mass Casualty Commission final report, Turning the Tide Together. Talked about that. We had a session last week, and if you haven't checked it out already, you may want to watch the video or listen to the podcast. Really interesting discussion with Jordan and Paul, covering things that really haven't been covered anywhere else. I've been following the media coverage of the Mass Casualty Commission report, and a couple of things that we covered that really haven't been elsewhere, which is, one is the RCMP's disclosure issues, and not only the RCMP, but the Attorney General of Canada, the lawyers for the federal government, and the disclosure issues there, and the Commission actually recommending an external audit of those disclosure processes and procedures. Second thing is a critique of Patterson Law, the law firm out of Truro that represented most of the victims' family members, and they were, integral to the process. The Commission talks about the potential for them to be in a conflict of interest and urges the Law Societies of Canada to investigate study that question as to whether, if you're representing somebody in a civil claim, can you also represent them in an inquiry claim. I had some feelings about that I talked about last Sunday as well, so encourage you to look at that. Actually covered that last week in the Rogers Brief as well. Okay, so that was the Mass Casualty Commission's update. The Nova Scotia Legislature was sitting the last couple of weeks. Long hours, short, long days, short session, 14 days. Passed the budget, a few other pieces of legislation. I looked through the Hansard documents, PDFs, for any mentions of the Mass Casualty Commission, following the issuance of the report on March 30th. There's not very many. There's a few questions in question period from the NDP, nothing from the Liberals, interestingly, asking about funding on gender-based violence groups. That was a recommendation of the commission, Mass Casualty Commission. And then wondering whether the government has responded or is prepared to respond to what the commission calls an urgent mental health crisis in the immediate area around Portapique and, Colchester, Truro, that area. Asked about a police review as well during question period, and there's really very vague language coming back from the government, no commitments at all yet to actually conduct such a review. So we'll see where that goes. There's short time frames where they're supposed to, the provincial government that is, and federal government together are supposed to put together a committee to study and implement the recommendations of the Mass Casualty Commission, so we'll see. Other things, like in the legislature, they passed a budget, like I said, had introduced legislation to speed up the licensing for healthcare professionals. I saw some blowback on that from the healthcare regulatory agencies, just because the legislation they feel isn't quite specific enough, and they feel they may have to approve people who may not be up to our standards for doctors, nurses, and other healthcare roles. But anyway, the Minister of Health says that kind of detail will be included in regulations. It would usually be the case. Other thing was the rent cap was extended at 5%. And so other than the budget, not particularly notable or groundbreaking legislation coming out of this session. Not unusual. Oftentimes the spring session of the legislature is just the budget. Of course, the budget is significant in itself and makes decisions on where the government goes. But in terms of legislation, typically the fall session is the busier one in terms of legislation. All right. Next story, a Nova Scotia issue as well, or story, and this is the stabbing that took place a couple of months ago, a month ago or so now, I guess, in Bedford at the high school there, CP Allen High School, 15-year-old. Now, Saltwire's reporting this week, the Chronicle Herald, CBC reporting as well, but Saltwire's a little more in depth, reported a little more detail about what took place, or what's alleged to have taken place, that the student, this 15-year-old, brought a knife to school, had it to his own throat, and when the vice principal and a secretary went to intervene, then turned the knife on them. And so was charged with attempted murder. Seems unlikely that, seems more like a cry for help on the student's part, looking for, wanting to show that in such a public manner. Certainly would seem to fit the criteria as somebody who was not serious about suicide, but rather looking for help. But anyway, we'll see. But attempted murder seems like a stiff charge. And also, as I talked about here before, the Crown has already announced that they would be seeking an adult sentence. All the more inappropriate given what took place just this week. Now, the accused is in Waterville. He's not at home. He's not at some other location. He's at the Youth Detention Center in Waterville. Appeared by video in court. And the judge, Judge Shear, agreed to a psychiatric assessment. Now, psychiatric assessments prior to plea can be done for either one of two reasons. One, for the person to potentially be found not criminally responsible, an insanity defense essentially, to say at the time they weren't criminally responsible for what they did by reason of mental disorder. Second potential purpose would be whether the person is fit for trial. In other words, whether they have the ability to instruct counsel, understand what's going on, understand that they're in a courtroom. It's a pretty low bar for that, but in the reporting, it sounded like the request was made, and the judge needs to agree to this. There has to be evidence presented that you can't just ask for this. The judge has to be satisfied that there are reasonable grounds to believe that an assessment is necessary. And the reporting suggests that this was only to determine whether the youth was fit for trial. Now, that is an issue. I suspect that the assessment would also be to determine whether at the time the youth had the requisite mental capacity and abilities, wasn't in such a state as to be criminally responsible for actions done at the time. So we'll wait and see on that one as well. It'll come back for plea. Paul Shepard from Legal Aid is acting for the accused. Didn't mention in the court, in the reporting who was acting for the Crown on this application. All right, Supreme Court of Canada cases. Two interesting ones came down this week. I think maybe only the two cases that were reported this week anyway. One is a case of impaired driving allegation. Breault, B-R-E-A-U-L-T, is the individual's name, who was found by the police walking away. There had been a report of an potential impaired driver on an ATV. Police showed up at a campsite, see a person walking away from an ATV, make a breath demand. Breault denies that he was driving, refused to comply with the breath demand. Well, the issue that made it all the way to the Supreme Court was that the officers at the time didn't have an approved screening device. They didn't have anything for Breault to blow into if he had agreed to the demand. But he had refused in any event. So they charged him with refusal, and this went all the way up the chain. And because the criminal code says that police can demand a sample, but that it must be provided forthwith. What does that mean in this circumstance? Well, the Supreme Court of Canada says that you must have immediate access. You either have the ASD on you, or it's got to be available like immediately. Like not call back to the detachment and get somebody to bring it over, but it's got to be there. And there's a reason for that, because at the time you are requested to give a breath sample, you are detained by the police. Normally, when you're detained by the police, you have the right to counsel. You have the right to call a lawyer and get instructions, all those things. Because of the timeliness and the severity and the seriousness of the type of offense, courts have long said that right to counsel, yes, it's a breach, but it's reasonable under the circumstances saved by Section 1 of the Charter, and therefore it's reasonable. But it's a balancing act, right? So in this case, where the breath device wasn't available immediately, that period where your rights are being violated by not having right to counsel is increased. And so what the court says is that breath demand was invalid because there was no ability by the police to affect the demand once it was complied with, had it been complied with. All right, next case out of the Supreme Court is a case called Murray Hall. It's a hyphenated last name versus Quebec. And in Quebec, so this is coming after the legalization of cannabis in 2018 by the federal government. Federal legislation says, yes, it's okay to possess up to a certain amount, to grow a certain amount. Well, the issue of growing is what came up to the Supreme Court of Canada in this case. Because in Quebec, the provincial government has said that you can't grow any. It's not a limit, it's not and anybody who either possesses a plant or is found to be cultivating a plant can be fined $250 to $750. Low fines, relatively speaking, but anything above the federal guidelines is a criminal offense in any event, and so would be dealt with otherwise. So these fines are just for those low amounts of plants found in somebody's possession. Now, what is the issue? The Constitution says, Section 91, sub 27 of the Constitution says that criminal law is the purview of the federal government, so they can make laws on criminal law. But the Section 92, sub 13 of the Constitution says that the province has the right to legislate on property and civil rights. So that the Supreme Court found that in this particular instance, what they call the pith and substance, the essential elements of the Quebec law was to protect the state monopoly, that is the provincial monopoly on the sale of cannabis. And so, in effect, achieve what they call a public health and security objectives. And so, in a sense, that's controlling property and civil rights, and it is not a direct conflict with the federal law. In that sense, it doesn't frustrate the purpose of the federal law. A person can still possess and consume cannabis. You just, if you're in Quebec, have to buy it through the proper channels. Now, looking at this case, you could see how this could certainly, it's not just, I mean, Quebec has an unusual legal system anyway. It's a civil system and it's different than the other provinces. But in this case, there's no reason why. So, in other words, Quebec decisions aren't always nationally applicable. In this case, it is. Those restrictions, I think, could be put in place in other provinces if provincial governments wished to do so. And we'll see if anybody follows suit after this Supreme Court decision on the Quebec law. All right. Next thing I want to talk about the Prairie Premiers, the three premiers of Alberta, Saskatchewan, and Manitoba, versus the Justice Minister, David Lametti. So what happened? Last week, Justice Minister Lametti met with Assembly of First Nations chiefs and discussed, among other things, this 1930 agreement between the federal government and what were, then to become the provinces, to transfer control of natural resources to the provinces, to Alberta, Saskatchewan, and Manitoba. Now, this is control of natural resources that other provinces already had. So it was sort of bringing those three provinces up to the equivalent of other provinces. Now, in that agreement, First Nations rights are not mentioned. So that's a key point. Now, in 2016, the federal government endorsed the United Nations Declaration of the Rights of Indigenous Persons, which, among other things, says that governments are required to make every effort to obtain free, prior, and informed consent of measures that will affect the rights of Indigenous peoples. So, the question is, from the chiefs to the minister, are you thus now prepared to look at this 1930 agreement? And Justice Minister Lametti said, yes, I will look at it. And he wasn't making any promises, but he said that his response won't be uncontroversial. And what could that mean? That could mean a lot of things. Maybe the chiefs won't be happy. Maybe the provinces won't be happy. Maybe it's some, nuanced interpretation of the UN Declaration. It's something, but why would you say that, right? If you had a thought in mind or a train of thought that's going in a certain direction, somebody's not going to be happy. So what? What could that possibly mean? Well, there's a few other things on the other side. One is the Alberta, I've talked about these pieces of legislation before, Alberta Sovereignty Act and the Saskatchewan First Act. Both claim to be pushing back against federal encroachment on provincial civil rights and use of natural resources, and claim in both cases that the provinces have exclusive jurisdiction over property development and natural resources. Well, that's not quite accurate. As between the provincial and the federal governments, yes, the provinces have that right under the Constitution, as we just talked about in the Supreme Court of Canada case, but the rights of Indigenous peoples throughout Canada, I don't know if I wouldn't say they necessarily supersede that, but they are independent in a sense of the relationship between the federal and provincial governments. And the UN would say that both provincial and federal levels of government need to respect the rights of Indigenous people. So, to resource development on their lands and the traditional territories. So, the two pieces of provincial legislation aren't quite correct, that the provinces have exclusive jurisdiction because they have to take into account the obligations to First Nations. But that doesn't necessarily mean having to go back and revise the 1930 agreement either, as between the federal and provincial governments, because in a sense it doesn't speak to those Indigenous rights. It doesn't, eliminate them or amplify them or do anything with them. Now, if anybody is going to renegotiate such a major agreement that's part of, an essential part of our federalism, one would think that you would do that in a more organized way, rather than certainly saying that you're thinking about it and that your response won't be uncontroversial. Maybe it was just a sort of what I think John Ibbotson described as a polite but empty assurance from the Justice Minister, but who knows? When you put it that way as he did, then it starts. I can see why it draws some suspicion. Although certainly the rhetoric from the Prairie Premiers has been predictably elevated, I guess I'd say. All right, last thing I wanted to cover is this Australian case, and I follow some British lawyers on Twitter. One is Jamie Susskind, who's a good author as well. Talks about the future of law. I've got one of his books, maybe not behind me, but here somewhere. In any event, he tweeted out this Australian case, and it was a foreclosure case, and from 2005, so it was a while ago, and it was a self-represented guy and his wife, but it seemed like the guy was the guy that was checking in on it, Stanley Sturgeon, all right? And Citibank was the bank that was foreclosing on him. Well, so what happened was he got his mortgage, he was making his payments, they were making their payments, and then Citibank took a little extra money out of the account unexpectedly and didn't really explain why. And the couple was very offended by this, and so they just stopped paying. They said, how can we deal with a bank that might do something like that? The judge sort of comments that might have been overreaction, but in any event, that was how it started. So he said the proceedings have been protracted, tortuous, and attended by a comedy of errors sufficient to inspire the producers of The Castle, which is a movie from 1997 with a respectable 7.6 on IMDb, to consider making a sequel. Funny movie. They were trying to take down this person's house in order to build, I think, an airstrip or something like that, but they refused, and that was the movie. So there was some confusion over the Citibank debits in the first place. They were offended. They stopped paying. Citibank sued for possession of the house. They got it, but the plaintiff appealed and then asked for a stay of execution so they could stay in the house pending appeal. The appeal was rejected, and so they wanted to appeal to a further level, but there was no stay. So they had to get out of the house for a little bit, but then the Federal Court of Australia allowed the appeal, struck out the statement of claim altogether, and so they were back in the house. Plaintiffs were back in the house. But Citibank eventually filed a new statement of claim, but there were some problems with the statement of claim, and there was a bunch of different motions coming through. He was back in court many times. The judge talks about how he was getting older and wasn't, but he was still holding up well enough to push the case through court. Still never paying the mortgage. Citibank was getting frustrated, just deciding, like, all right, let's cut our losses and just try to get something out of this. In 2004, there was a finding for Citibank, and it seemed like everything was done and wrapped up, and the bank was going to win. But then Sturgeon, I think is how you pronounce it, came out with one final thing, a final bullet, that he found out through the Australian Securities Commission that there was a company extract there that Citibank had been deregistered in June of 1996. So anything that they did after that was invalid. They didn't exist as a corporation, even though they were doing business, conducting business every day, going to court, doing all these things. Nobody apparently had noticed this, but Citibank, nearly 10 years before, had been deregistered by the Australian Securities Commission, and so didn't exist as a legal entity. So they couldn't start up a new statement of claim as they'd done. They tried to do, and there were some problems with it, but all of that was a nullity, and so the case was done, and they get to keep the house. So amazing what can happen sometimes as a self-represented litigant. So all you self-represented litigants, just one there to, I guess, put some wind in your sails if you're feeling discouraged. Sometimes things can really work out, and you just gotta wait for that final moment and throw the Hail Mary. Okay, those are the cases I wanted to talk about this week. Like I said, I'll be on with Jordan and Paul on Sunday night at 9:15 live on YouTube. check it out there or a few days later on podcast. And until then, thanks for watching and thanks for listening, and we'll see you next time.